Namaskar. Dear students, under the Model 2 of the medical insurance and related topics, we are going to deal with the legal aspect of medical insurance. Medical insurance is the bigger industry wherein you have to be a part of that process, maybe as a healthcare provider or may as be a part of a team which verifies the claim and pass the claims or sometimes deny the claim on the basis of its merit. So you may be on any part of the insurance regulatory process. You sometimes may be the beneficiary of the medical insurance also whenever you opt for the medical insurance. To deal with this session, we are going to discuss with legal aspect of medical insurance. Under these objectives of the session are the roles of various regulatory bodies which will keep a control over the insurance related matters. What are the legal implications of the insurance denial? How to handle the grievances whenever some disputes are being raised, and we are also going to discuss some case studies on the legal challenges in medical insurance. So on your screen there are the learning objectives of our session. The Insurance Regulatory and Development Authority of India is the primary regulatory authority which protects the basic rights of the policyholder. The Ministry of Health and Family Welfare also is the regulatory body having the direct supervision over such medical health related products and plays a crucial role in formatting and formulating the healthcare policies and implementing in the health insurance schemes. The Ministry of Health and Family Welfare closely with the Insurance Regulatory and Development Authority of India ensures the coordination and alignment in regulating the health insurances. The various consumer forums may be at district, state level or national levels handles the various disputes, the grievances to the insurance related policy and provide a platform for dispute resolution. The consumer forum also plays an important role in safeguarding the policyholders and to provide them the fair treatment. The regulatory body like IRDAI is a statutory body under the Act of Parliament, that is Insurance Regulatory and Development Authority Act of 1999, for overall supervision and development of insurance sector in India. The key objectives are displayed on your screen. It includes the protection of interest, the speedy and orderly growth of insurance industries, speedy settlement of genuine claims, effective grievances redressal mechanism, promotion, fairness, transparency and orderly conduct in financial market dealing with the insurance. Prudential regulation while ensuring the financial security of the insurance market are the key objectives of this authority. Here is the logo displayed on your screen. The main functions of the authority, it includes the regulation and supervision of the insurer, their protections in terms of their rights, the product regulations are to be laid down, then premium and pricing regulations for various policy products and insurance products are very well regularized by the authority. The solvency and financial health of the insurer is the prime concern. The market conducts and the ethics has to be supervised, facilitating the market development, public awareness about the insurance and making them educated by means of awareness programs and various education schemes. The role in cases of dispute resolutions, and the data will be available with the authority in terms of in good number of the stakeholders. So the research can also be done with the data collection, and these are all the functions of the Indian Regulatory Development Authority of the functions of the Insurance Regulatory Development Authority of India are displayed on your screen. The conclusion is that IRDAI plays a critical role about the integrity of insurance market, and being the regulatory authority, it also has got a framework which ensures the manner with fair, transparent and best interest of the consumers the services to be provided with. The ethical consideration in medical insurance practices, the patient confidentiality, the transparency and disclosure, avoiding the conflicts of interest and fair and equitable treatment is the ethical consideration on the medical insurance part. Because patients' confidentiality should not be breached. It is a crucial part, and balancing the transparency with the privacy should be the prime importance. The disclosure with the others should be avoided, and the information and the providing clear and comprehensive information about the policy related matter to the patient should be done in a proper way. Avoiding the conflict of interest. Medical professional must prioritize the patient in the best interest and avoid benefiting from the insurance decisions. Fair and equitable treatment. Ensuring fair treatment for all insured individual regardless of their backgrounds or health status. This is the equitable approach, and with this approach the fair and equitable treatment should be offered. This is the ethical consideration on the part. There are some legal implications also. So the insurance denial have significant implications in terms of the penalties sometimes will be attracted, the clarification will be sought from the companies on the basis of which they have denied it. So denial of claim is the very crucial thing in the process of medical insurance, and it will be a shock for the policy holder, the insurer, when such denial will be there. And it can be either made from the pre-existing conditions or the policy excluding criterias, or sometimes related with fraudulent claims, or either by the non-payment of the premium. Pre-existing conditions means the disease which were earlier there. Policy exclusions means not all conditions and not all diseases are covered under certain policy products, medical health, insurance. Those which are excluded from the policy products will not be covered. And if the patient is actually claiming for the excluded conditions, then the denial may be authentic or genuine. The fraudulent claims also will be denied. Those has to be detected only after the proper verifications. And if the insurer, the policyholder fails to pay the premium and the payouts of the policy, then yes, after the grace period even they are failed, and if they have not paid in due course in the future, the policy may get lapsed and they can't claim the benefits of the policy for the purpose of their health insurance. So such are the basis and the various grounds on which the denial can be made. But the individual has got a right to challenge if the insurer decision, though, is not on the earlier ground what we discussed, and in that condition they can approach to the authorities, ombudsman or the various forums for the reason to get clarified. Even it can start with the customer care approach, communications with them, maybe telephonic, maybe the written, maybe the email related conversations or the email related communications can solve the issues, but one has to follow the process. But yes, it remains the challenge till the insurance policy is accepting the grounds. It is advisable for the individual to consult the legal professions in such conditions so that they can approach appropriately, they can file their considerations which can be executed properly and the best outcome will be possible. The legal implications of insurance denial are displayed on your screen. The screen will be showing how the violation of the Insurance Regulatory and Development Authority of India guidelines will be done if the denial is made. It is also attracting some clauses of the Consumer Protection Act. The breach of the Contract Act will also be one of the implication. IRDA's ombudsman scheme will be then coming into action. Discrimination and violation of the rights, the public interest litigations, PIL sometimes will be filed maybe by the other individuals on a common issues. So these are the legal implications on the insurance denial grounds. The violation of Insurance Regulatory and Development Authority of India related to the denial claim. In unfair practices, IRDA has established guidelines to prevent the unfair trades. If the insurer violates this guideline, they can be penalized and the policyholder may be entitled for the compensation. So such unfair practices attracts the penalties. The Consumer Protection Acts legitimately denying the claim considered to be the unfair trade, because whenever the consumer is paying the premiums and opting for the insurance, the denial of the claim on the genuine ground should not be made, but the services to be provided. But if it happens, then it is the violation of the basic right. So the policy holders can file a complaint in the Consumer Dispute Redressal to seek the redressal, including the compensation and various damages. Also, deficiency in services on the part of policy providers and the service providers can be seen, and the policyholder can file the complaint for the same. The breach of the contract is taking place in this situation because whatever contract in terms of the policy purchasing and undergoing that health insurance is governed by the insurance policy contract, and denying a claim will violate the terms and conditions of that policy, and this is a clear-cut breach of the contract. The policyholder may take the legal action to enforce the contract. IRDA's ombudsman scheme. Ombudsman's redressal is one of the strongest point the authority has offered. It is the system where ultimately the dispute will be listened will be resolved, will be redressed, so as to convince the policyholder to provide best of the best services. The discrimination and violation of the rights, non-discrimination remains the insurance companies cannot deny discrimination and violation of rights, and non-discrimination by means of denial of the claim should be avoided on the basis of their race, religion, gender or pre-existing condition which are covered under the policy. Such denial could lead to legal action under the anti-discrimination laws. Sometimes the public interest litigations, which are popularly known as PIL, can also be filed if the social issues and system issues are there. The denial of insurance claim affects the large group of people. In that case, PILs will be filed. The penal consequences will also be attracted. The fraudulent practices, such as involving in any of the fraudulent practices on the part of policy providers or the policy holders or the insurer, the penalties will be attracted, and denying the claims in cases of genuine grounds is accepted, but if the claims are made falsely, fraudulently, and if those are denied, that can be considered as the fault finding, and in that condition the faulty applied claims will be taken on board. The concerned will be penalized as per the various laws. The court litigations will also be filed. If the policyholder believes that their claim was wrongly denied, they may file the suit seeking the enforcement of the insurance contract, and even they can approach to the higher centers, higher courts in claiming for the significant amount and escalate the process of their claim settlement. Even they can approach to the high courts and in Supreme Courts also if the things are not settled at any of the level. So how to handle the disputes and grievances? The Insurance Regulatory Development Authority of India has got a system of handling such disputes and grievances. So the redressal mechanism is there. What mechanism is available under that, we will see. The authority has provided it under its own consideration. The various other forums and the various courts are also available to provide the better way out and the options to take the legal actions there. So handling disputes and grievances in medical insurance in India can also be done by means of internal grievance redressal mechanism of the insurance company itself. So company firstly should be the primary initiative. They should listen to their insurer. An initial complaint, the policyholder should file a complaint directly with their company. Either this can be done by the customer service providers, phone, email, or on the online portals also they can file it. The insurer is required to provide the acknowledgement within 3 days of receiving such complaint. The insurance company is mandatorily expected to provide the acknowledgement. And even you might have seen, wherever you are approaching to any customer service, immediately you are getting the acknowledgement number. The same is expected in the insurance related disputes also, and the insurer is expected to follow this basic first approach. The resolution timeline is also said to be within the 15 days of such after receival of the such complaints, and if the policyholder is not satisfied with the reply, then with the resolution whatever the company is making, then they can escalate the issue further. Where they can approach to the grievance redressal cell. They can file the complaint to the Insurance Regulatory Development Authority of India, IRDAI. If not happy with the insurer response, they can file a complaint with the grievance redressal cell, and after such complaint, which can be filed either online or through the integrated grievance systems, maybe by the writing. The complaints can be filed online or through the writing, and it monitors the complaints and ensures the insurers to follow the rules and resolve it on priority. The insurance ombudsman is another system of dispute redressal. The role of ombudsman is to look to the case who provides cost effective and quicker solutions after going through the complaint in details. So this is said to be the ultimate redressal mechanism, and under some conditions the complaint can be lodged with the ombudsman. If the earlier complaint is not resolved within 30 days, and if the policyholder is not happy with earlier information provided, or if the claim is within 30 lakhs, then in such conditions such appointed ombudsmen are coming into action to provide the quicker solutions. The process of this complaint redressal is that ombudsman reviews the complaint, found valid, then they can recommend the fair solution or make an award of binding on the insurance policy to provide the charges. The ombudsman's decision must be made within the 3 months of receiving such complaints. So timelines helps the policyholder to go in a manner to have their solution, or else they can approach to the higher authority for their satisfaction. The consumer dispute redressal commissions, these are consumer forums or consumer courts. Those are of the district, state and national level. So the jurisdiction will be as per the locality of the individual, and policyholder can file a complaint with the Consumer Disputes Redressal Commission, maybe at the district level, state level or national level in a stepwise manner. If they are not happy with the earlier forum, they can approach to the higher, and also depends on the amount. The district forums awards the claim up to crores, the state up to 10 crores, and above 10 crores the national commissions are nowadays offering the claims. The procedure is to file a formal complaint which may involve the legal representation. However, it is a powerful tool for the policyholder for seeking the compensation for deficiencies in service and for the unfair trades. Compensation can be made by means of awarding the financial loss related compensation. It may include the mental agony and other damages, including the punitive damages in cases of serious and wrongdoing by the insurer. The civil courts also sometimes will be in action whenever the litigations are filed there. For complex cases, or if the large claims are there, policyholders may choose to file to the civil court. This process can be lengthy or more expensive, but can result in binding the legal decisions and for the higher compensation awards. Public interest litigations, the PIL, can be filed in cases where the disputes involve the broader public interest or the large number of people are involved as a policyholders, and if they are not been properly cared with the policy products, in that condition the PIL will be filed, maybe in the high courts, maybe in the Supreme Courts, to address the systemic issue. The complaint management of IRDAI is the direct complaint they can make so that the unresolved grievances can be dealt directly by the company, and alternative dispute resolutions are also there. Mediation and arbitration is another option. Some disputes may resolve through the mediation and the arbitrations, either through the insurer's alternative disputes resolution mechanism or independent ADR institutions. This is a less formal and quicker process compared to the legal litigations. So, handling the disputes and grievances, there are some steps. File a complaint with the insurance company first, escalate to the IRDAI's grievance redressal cell if not resolved there, approach the insurance ombudsman for unresolved issues within specified limit, file a complaint to the consumer forum for more formal redressal, and civil litigation as a last resort for the complex or high value claims. Policyholders should keep thorough documentation of all correspondence, decision and action taken at each step to support their case during the grievance processes. The summary of various steps are displayed on your screen. Here also you can see on your screen how the filing of the complaint, how the mediation and conciliation is resolved, how the ombudsman scheme is helping the individual, how the insurance appellate tribunal is filing and resolving the issues is displayed on your screen. There are some cases to be discussed on the legal challenges in medical insurances, which we are going to discuss one by one. So, the case studies. The case number 1, wherein the legal challenge in medical insurance in India have often led to significant case law, setting precedents of how dispute between policyholder and insurer are handled. Here are some notable case studies that can highlight the key challenges. Vishwanath Wagmare versus National Insurance Company Limited, which has happened in 2012. The background was the policyholder named Vishwanath Wagmare had a mediclaim policy with the National Insurance Company Limited. His claim was denied later on because of the grounds that the illness was of a pre-existing type. The legal issue in this case raised was the insurer was justified in denying the claim on the basis of pre-existing condition, particularly when the condition was not explicitly mentioned as such in the policy. So, it was not clearly mentioned, it was the ambiguity which was noted, and the outcome in terms of National Consumer Dispute Redressal Commission NCDRC, which ruled in favor of the policyholder, stating that the insurer had not provided sufficient evidence to prove that the illness was pre-existing, and the commission held that the insurer could not arbitrarily deny the claim. So it was the decision in favor of the policyholder, and accordingly it was not clearly mentioned in the policy documents about the pre-existing conditions, and the claim was settled by giving the relief to the policyholder. The impact of such case will be the case reinforcement the principles that insurance companies must provide concrete evidence that they are denying on genuine grounds, such as a pre-existing condition, and cannot act arbitrarily. So it is the responsibility of the insurance company to diagnose the conditions, to get the health details of the policyholder, so that whenever such a time will come that the patients want to get benefited with their health conditions, they should not claim that they are pre-existing diseases. So accordingly, such claims should be avoided. The case 2 is related with the United India Insurance Company versus Manubhai Dharmi Sinhabhai Gajera. It was in the 2008, where the policyholder Manubhai Gajera again had a mediclaim policy with the United Insurance Company this time, and his claim for medical treatment was rejected on the ground that he had not disclosed certain details about his own health conditions during the policy issuance at the beginning itself. So the legal issues were raised. The issues stated that the case revolved around the issue that the non-disclosure of the conditions and the facts at the time of the issuance of the policy, which was really important, and whether those are justifiable for the denial of the claim or not. The Supreme Court in these conditions ruled that non-disclosure of the facts that were not material to the insurance contract did not justify the rejection of the claim. The court emphasized that the insurers must clearly prove that the non-disclosed information was material and directly related to the risk being insured. So, Honorable Supreme Court has taken such a stance in favor of the policyholder, which has helped and provided the relief to the policyholders. Impact of such cases will be in terms of the impact later on was asking the insurance company to provide the clarity on the doctrine of materiality in the insurance contracts, reinforcing that the insurance cannot deny claim on the basis of non-disclosure of immaterial facts. The case related with Oriental Insurance Company Limited and Sony Sherian in the 1999 is the third case to be discussed. The background of this case is that Sony Sherian filed a claim under his health insurance policy with Oriental Insurance Company Limited. The insurer denied the claim, arguing that the treatment received was not covered under the policy term. The dispute entered around the interpretation of policy terms, specifically what constitute a reasonable and customary, the medical expense, and whether the treatment fell within the scope of the policy or not was the legal issue in this case. The outcome of this case, the Supreme Court ruled in favor of the Sony Sherian, holding that the insurer could not impose its own interpretation of what was reasonable and customary without clear and explicit policy terms. The court also emphasized the principle that any ambiguity in the insurance contract should be interpreted in favor of the policyholder. So the impact of this case was established in terms of the principle that insurance contract should be interpreted in favor of the policyholder in case of any ambiguity, and the insurer cannot unilaterally define terms and deny the claims. The another case to be discussed is a Sikka Paper Limited versus National Insurance Company Limited, which took place in the year 2009. The background of this case was Sikka Paper Limited filed a claim under the Mediclaim policy for the treatment of an employee. The claim was denied by the National Insurance Company Limited on the ground that the treatment was not covered under the policy. So here it was the group policy offered by the employer about their employee, where the National Insurance Company is denying. And the legal issue raised in this condition was the primary issue related whether the insurer's interpretation of policy exclusion was justified and whether the denial of the claim was lawful or not. So the outcome of this case was the Honorable Supreme Court of India ruled in favor of Sikka Papers Limited, stating that the insurer had incorrectly interpreted the policy exclusions. The court reiterated that exclusions in the insurance policies must be clearly defined and communicated to the policy holders. The impact of such case will be long lasting, and the case highlighted that the importance of clear communication of the policy term and exclusion by insurer, and reinforced the protection of policy holders from arbitrary claim denial. So such cases are the milestones, and every time the policy holders will be taken at the center to consider their part, and the policy providing companies are guided with various guidelines to make their documents clearly without any ambiguity and without any doubts. So to come to the another case which was held in the 2004 was of the Life Insurance Corporation of India, that is LIC versus Anirudh. The background of this case was the LIC denied the claim on the ground that the policyholder had alleged suppressed material facts at the time of purchasing or taking the policy. Means everything was not disclosed on the part of Anirudh, it was the claim. The legal issues was focused on whether the alleged suppression of the material fact justified the denial of the claim, and whether the insurer had fulfilled its duty to verify the policyholder's information at the time of issuing the policy. So the issues are raised whether it is a fault on the policyholder's part or it is the fault on the policy provider's part, whether to obtain the maximum information. The outcome made by the Honorable Supreme Court in terms of insurer had a duty to verify the information provided by the policyholder at the time of issuance of such a policy. The court also ruled in favor of the claimant, stating that the insurer could not rely on the alleged non-disclosure or mispresentation after the policy was issued without thorough verification. So it was also laid the insurance policy responsible to get the thorough verification, and which is mandatory for the denial. The impact of such case and the judgment, it underscored the responsibility of insurers to conduct the diligence where at the time of the issuing such policies and restricted their ability to deny the claim based on the alleged non-disclosure facts should be made. So, if the policyholder is not providing the information, it is the responsibility of the policy provider team, policy provider corporation or the companies to obtain to its maximum. The another case, it is related to the New Medical Assurance Company Limited versus Srimati Shanti Mishra, which was held in 2012. The background of this case was Srimati Shanti Mishra had a Mediclaim policy again with the New India Assurance. Her claim for hospitalization expenses was denied on the ground that the treatment was of a pre-existing condition, which she allegedly not disclosed when the purchasing. So many of the times these pre-existing conditions are the denial ground. We have seen 2-3 cases here, and in the introduction also we have seen that the common grounds are there for denial. But if it is the fault on the policy providers, then the denial is not accepted. The legal issue again in this case was whether the insurer could not deny the claim by asserting that the illness was of the pre-existing type without any substantial evidences. The outcome of this case was the court ruled in favor of Srimati Shanti Mishra, stating that the insurer had failed to prove that the illness was pre-existing. The court emphasized that insurer must provide adequate evidence before rejecting the claim based on non-disclosure or the pre-existing condition. The impact of this case was it further reinforced the requirement for the insurer to provide clear and convincing evidences before denying such claims on the ground of the pre-existing conditions. So, such cases are there. In another case of the ICICI Lombard General Insurance versus Sudharani of the 2010 case, wherein her hospitalization was rejected on the ground that it was related to the again pre-existing condition, and the denial was valid. The outcome of this case was in favor of Sudharani, stating that the insurer had not provided sufficient evidence that the condition was of the pre-existence, or the policyholder had adequately informed about the exclusion. The impact of this case again related to the pre-existing condition underscored the importance of insurer clearly communicating policy exclusions to policyholders and ensuring that such exclusions are supported by substantial evidences before any such denial. So, the another case related with the National Insurance Company Limited and Hindustan Safety Glass Work Limited, which took long back in 2004. The Hindustan Safety Glass Work Limited filed a claim under the group health insurance policy for the treatment of one of its employees. The claim was denied by the National Insurance Company that it was not covered under the policy terms, and the legal issues raised related whether the insurer's denial was justifiable on specific terms of the policy or not. The court in this condition held that the Hindustan Safety Glass Work Limited was right and the decision was made in their favor, ruling that the insurer had wrongly interpreted the policy terms to deny the claim. The court held that policy term should be interpreted in a manner that is fair and reasonable to the policyholder. The impact of this case again is that the insurance policy terms should be interpreted in a manner that benefit to the policyholder should be made available, particularly when the terms are ambiguous and unclear. So, in cases where the ambiguity lies, the doubt of, in case of the benefit of doubts related with the ambiguity lies with the policyholders. So, these cases are helping us how the insurance related allegations will be made, where they can approach for the various redressals, may it be the company itself, may it be the ombudsman, may it be the Insurance Regulatory and Development Authority of India, or various forums or the courts are the options available for them. And the complexities involved in health insurance and disputes we have seen now. The court's role in interpreting the insurance policy to protect the consumer rights. Every time the consumers are to be listened properly, may it be by the authority, may it be by the courts, company will always try to deny, but the other forums will always listen to the policyholders. The ruling have helped to clarify the key aspects of insurances law, including interpretation of various policy terms and doctrine of materiality, and the obligations of insurance provides clear, transparent communication to the policyholders. So, with this we are ending our session about the medical insurance and the legal aspects in cases of any of the allegations in which. So, you have to think of various legal aspects which may arise. We have also discussed it through the various case studies, and there are various allegations can be made for the medical insurance. The claim denial remains the one of the major aspect which took various levels for the patients, and accordingly the redressal to be made by the concerned authority. Hope you have understood the various mechanism for the complaints, the disputes, the grievances and the redressal thereon by various means, because anyhow we are going to be a part of such a medical insurance team and the industry. You may work at any of the point of the time, so it is you to understand it meticulously through your electives. Namaskar.